This video lecture is for ST219 Commercial Law. This is the fourth study session. We are going to continue our discussion on law of contract. This study session will further teach you the capacity of an illiterate to enter into a contract, as well as introduce you to the vitiating element of contract, that is, the element that can invalidate and otherwise make an agreement valid. On completion of this study session, you should be able to explain the protection afforded an illiterate in law in respect to contract. You should be able to itemize and discuss the vitiating element of contract. And you should be able to explain misrepresentation and state its types. Who is an illiterate? It appears that from the cited cases, the test of illiteracy is a relative one. In the case of PZ and Co. versus Usau and Kantoma in 1961, the court considered an illiterate person as someone who is illiterate in the language used in the document under consideration. It is irrelevant that the person might be illiterate in some other language. In case of Zaria versus Okon 1960, the Supreme Court held that although a person may be sufficiently literate to sign his name and read figures, yet may not be sufficiently literate to understand the meaning and effect of the document he is signing, and such a person are therefore an illiterate that will be availed the protection provided by illiterate law. By the provision of Section 3 of the Illiterate Protection Act, it says that anyone who prepare any document where an illiterate person is a party must write his name and address on the same as the writer of the document. If the illiterate person is supposed to sign the document, then it must be indicated on the document that prior to it being so signed, it was read over and explained to the illiterate person, and that the signature was made by such person. Otherwise, such document shall be void. This process is known as jurat. Now, capacity of lunatic or drunkard to contract. A person who is of unsound mind can be under lucid interval at certain time. Lucid interval is a state where he is not of unsound mind and can form a rational judgment about the terms of the contract. At this state of lucid interval, he can enter into a contract. But if he has entered into a contract when he is not under lucid interval, then the contract will be void. For example, when a person who is undergoing treatment at a mental asylum, when such person escape and go to his village to sell his property, such a contract is totally void as the person who sells the property is undergoing treatment at a mental asylum. Likewise, a drunkard in a similar position as a lunatic. If a drunkard enter into a contract with another person when the former is in a state of intoxication and that he did not know what he was doing and the other party was aware of this fact, then the contract is voidable at his option. Vitiating elements in a contract mistake. The issue of mistake arises in a contract where one or both parties to a contract enter into it under some misunderstanding or misappreciation of facts. This can lead to making their consensus addendum, which is a necessary evidence of a contract, to be lacking or illusory. However, what amounts to mistake in ordinary sense may not be mistake in law. For instance, where a party bought a horse under the belief that the horse is sound, it cannot recover the purchase price if the other party never made any representation or contracted out that the horse is sound. There are various forms of mistake, which are: one is a common mistake, another is mutual mistake, and another is unilateral mistakes. The purpose of relief in in contractual mistake is to mitigate the arbitrary effect of mistake made on contracts. This relief can be in form of recession, it can be in form of refusal of specific performance, and it can be in form of rectification. Now we talk about misrepresentation. The term misrepresentation is an untrue or misleading statement made by one party to a contract during negotiation leading up to contract, which induced the other party to enter into such contract. Misrepresentation consists of statements of facts, past or present, and not of honest opinion or intention or of law. Types of misrepresentation. Misrepresentation is divided into three categories. The first one is fraudulent misrepresentation. This is a false statement which the maker knows is false or does not have an honest belief in its truth or is recklessly careless as to whether it is true or false, as in the case of Bangbala versus Deputy Sheriff in Lagos in 1966. Another one is negligent misrepresentation. It is one made by a party who holds a duty of care to another party who relieve on the statement to his detriment. That is, when there is issue of trust, when somebody believes that whatever that person says is the fact. This can be seen as in the case of Alibeme and Co. versus Hewler and Partner in 1964. Another type of misrepresentation is innocent misrepresentation. This is a false statement made by a person who honestly believes it to be true. Misrepresentation which is not neither fraudulent nor negligent. This is a type of misrepresentation made without fault of the maker, as in the case of Ali Brenner and Co. versus Heller and Partner Limited. We have come to the end of this study session, and I believe you enjoy this study very well. You can read through your study pack further to understand what we have been discussing. Thank you for listening. See you in the next class.